Colorado rental laws govern the rights and responsibilities of both tenants and landlords, whether dealing with lease agreements, evictions, property disclosures, or returning the security deposit. It's important to understand what state laws say in order to avoid any landlord-tenant disputes or even legal consequences resulting from a violation. In this video, we'll cover what Colorado law says about lease agreements, property disclosures, security deposits, and evictions. We're eForms, the largest online database of fillable legal forms. Stick around to grab a fillable lease agreement or eviction notice at the end of this video. First things first, what is a lease agreement? A lease agreement is a rental contract between a landlord and a tenant. Depending on the type of agreement, whether it's a month-to-month lease, a standard lease agreement, or rent-to-own, both the landlord and tenant are bound to the specific terms regarding the length of the lease, termination, and more. Because a lease agreement is legally binding once it's signed, breaking the contract can result in hefty fines or even legal action. Now let's cover required disclosures. The state of Colorado does not require the landlord to make any disclosures to the tenant about the property. Under federal law, however, the landlord must provide a lead paint disclosure if the residence was built before 1978. Next up, here's what you should know about security deposit laws. While Colorado does not have any maximum limits on how much a landlord can charge for security deposits, the state does have some rules about when the landlord must return the security deposit to the tenant. If the lease does not include a return timetable, the landlord must return the security deposit within 1 month of moving out. If the lease does include a return range for the security deposit, that duration must be within 60 days. If the lease is broken due to a hazardous condition caused by gas equipment on the property, the landlord must return the security deposit within 72 hours. Finally, let's go over Colorado's eviction laws. In Colorado, a landlord may evict a tenant under the following conditions. Non-payment of rent. If the tenant is late on rent, the landlord can issue a 10-day notice to pay or quit. This gives the tenant 10 days to pay the rent in full, along with any penalties, or vacate the property. If the tenant complies and moves out within 10 days but fails to pay the unpaid rent, the landlord has the legal right to use the tenant's security deposit towards the unpaid rent. Non-compliance. If the tenant breaks any portion of the lease other than late rent, the landlord may give the tenant 10 days to comply with the lease. If they do not cure their violation, then the tenant must vacate the property. Termination. If the landlord wants to terminate a lease without any cause, they must give advance notice to the tenant. The requirements depend on how long the tenant has lived there. For tenancies longer than 1 year, 90 days notice must be given to the tenant. Additionally, the landlord must generally cite one of the following justifications: selling the property, demolition or conversion of the property, substantial repairs or renovations, landlord or family member moving in, tenant's refusal to sign a renewed lease with reasonable terms, or history of non-payment of rent. For tenancies less than 1 year, the required notice is as follows. Tenancy of 6 months to less than 1 year, 28 days. Tenancy of 1 month to less than 6 months, 7 days. Tenancy of 1 week to less than 1 month, 3 days. Tenancy for less than 1 week, 1 day. Want to learn more about Colorado rental laws? Visit the link in the video description for a comprehensive breakdown on all things related to lease agreements, evictions, and more.